in 1994, and again in 2000 and 2005, and in the Trafficking Victims Protection Act of 2000 and 2008. In all these roles, she has been a one-woman whirlwind, writing manuals, training lawyers, and spreading the word wherever she can on how each of us can become involved in combating violence against women. During her 17-year litigation career prior to joining Legal Momentum, Ms. Orloff founded and directed the domestic violence program at IUTA, a legal services agency that served the interrelated legal and social service needs of battered immigrant women and children. She has also published numerous social science journal and law review articles on women's experiences with domestic violence, sexual assault, and immigration and immigrant victims' legal rights. Her work on behalf of immigrant women has earned her national recognition not only for the Daynard Public Interest Fellowship Program, but also the 2007 Sheila Wellstone Award, awarded to the National Network to End Violence Against Immigrant Women, the 2007 annual Rosalind B. Ball Award, presented to Leslye by the Women's Law Center of Maryland, and for her contributions to the field of family law, a Kellogg National Leadership Fellowship in 1994, and a Harvard Law School Wasserstein Public Interest Law Fellowship in 2002. Last night I was watching a new PBS show about midwives. There was a young woman who had just moved into this practice. She was treating a patient who had syphilis and who had done nothing about it for months. All of her patients were living in squalor. And she turns to one of the nuns and she says, "You know, I never knew that people lived like this." And the nun turns back to her and says, "They do, and it's our job to care for them." That's the kind of model that you've set for all of us, and we appreciate it. We're looking forward to hearing your remarks today. And to the extent that all of us want to get involved, I've been asked to remind you that a voter registration drive, nonpartisan drive, is going on right now this week from 12 to 1 at the Doxter Commons for those who want to get involved in this or any issue that interests you. So thank you so much for coming.
Thank you. Thank you very much. Thank you very much. It's a pleasure to be here. I always love coming and talking to law students or future lawyers. A lot of that work, when they talk about me being a one-woman, whatever, as many of you who know me, most of my career been able to do what I've been able to do because I've been supported by lots and lots of really fantastic law students, co-op students, undergrads, advocates, all kinds of interns. And so I'm a believer that I had the pleasure as a law student of doing an internship at a place called Public Advocates in San Francisco, where I was mentored and learned that, and really took it to heart, that one person really could do a lot, if you put your mind to it, and that's what I try to do every day when I get up, is trying to make a difference in the world. And it's really exciting to be here and encourage many of you to do the same. How do I make the PowerPoint go? Where's the guy? He doesn't. Hold on. There we go. The old-fashioned way. I prefer that way. The down key works perfectly. So what I'm going to be talking about today is, I'm going to start by giving you an overview of what essentially the world looked like before the Violence Against Women Act in 1994, and how far we've come, and talk a bit about what led to that, because what we're learning is that lawyers and advocates, and lawyers who are advocates, one of my really proudest days was when an advocate stood up at the back of the room when I was doing a training and said, "You're not a lawyer, you're an advocate." And so those of us that consider ourselves both, what we've learned through the Violence Against Women Act is A, bipartisanship is possible, and I still believe that, even though at the end of my talk we'll hear some of the current problems we're facing. And B, that collaboration, like real relationships with law enforcement and police and prosecutors and faith-based organizations, advocates and attorneys, women's rights groups, victim rights groups, immigration groups, and finding a way to work together is what's created all this. And the stories, the heartfelt stories of thousands and thousands of women that advocates and attorneys around the country have collected and shared. In 1993, what did it look like? There was little access to justice for immigrant and LEP, limited English proficient survivors, police, prosecutors, courts. When I was working in Washington, D.C., in the 80s and early 90s, it wasn't until the early 90s that they had any Spanish-speaking police officers. And so essentially the work that we did, the interns that we had were the interpreters. I was the lawyer, and we'd go, literally my clients would call my house, and I would have to call the police because they couldn't call 911. So that's what it was kind of like back then. Immigrant survivors, no matter immigrant victims of domestic violence who could have been in 12-year marriages and had 3 or 4 children with a U.S. citizen husband, had no independent access to immigration status. There were few programs nationally. I'd have to ask Martha, I think the original group might have been 15, and then I think it grew to about, when we passed the Violence Against Women Act, maybe we had 40 or 30 of us that had figured out how to work together by that time. And then there was literally no language access to government services for immigrant survivors back then. Most of the organizations that worked together to create the Violence Against Women Act immigration provisions were either immigrant rights, women's rights, or victim rights organizations. We all were doing direct services in different ways. I was a family lawyer. I learned immigration law by writing it, essentially. I actually never practiced immigration law, although I teach it all the time. I have a lot of experience with particular parts of it. But again, collaboration, I learned from the best of them when it comes to immigration lawyers. And that kind of collaboration has been essential to this work. Most of the programs in the early 90s that were doing this work had very little money. We were all pretty isolated from each other. We communicated by phone, and you guys might remember what fax machines are. Literally, IUTA didn't have one at the time, and my father bought one and donated it to IUTA so that we could do VAWA, because we had to communicate. I was communicating with Martha in New York and Bill Tamayo and other folks in San Francisco, and literally we'd go into meetings with Kennedy's office, make a phone call, send a fax, and there'd be a fax on the floor in the morning from the folks in San Francisco, and I'd run back to the Hill with it. And that's kind of how we did it back then. No internet, lots of overnight mail. And so what happened was there were a few immigration options and virtually no access to the family courts. Unless you had a Spanish-speaking attorney, I was the only one in Washington who knew what a protection order was, and eventually was able to, hire advocate interns and lawyers who came to work with me at IUTA who did as well. But it was a very, very different day and age. But what we understood is that as VAWA the Violence Against Women Act was being formulated, what we understood was that there was a real need to sever the power and control that the batterer, we were talking about domestic violence back then, had over the victim. And that we come from a country where early in U.S. history, and it came from England, there was something called coverture, which basically meant the husband owned his wife and children. And there was a period in the early 1900s where if you were a U.S. citizen woman and you married a man from another country, you lost your citizenship. Anybody guess what year it was that U.S. citizen women could begin filing papers to give lawful permanent residency to their husbands? 1952. And so that's the history we come from. It's not that long ago that, that gender equity in the immigration world, many would argue, still doesn't exist. But to a certain extent, didn't exist at all until the 1950s. And so what happens is you had this power and control. You had people, when we started with the Violence Against Women Act, who had a legal right to be here. They were married in legitimate marriages to U.S. citizens and lawful permanent residents, and they had a green card waiting for them. But their perpetrator, the husband, usually, would control when to file, whether to file, etc. And so victims got locked in abusive relationships. And what we've learned as we've moved beyond the domestic violence into the sexual assault realm in particular is that same power dynamic exists between employers and employees in many, chicken processing plants, agricultural settings, et cetera, in the United States today. And that's why the U visa has been the crime victim visa has been so important to many women, because it helps sever that power and control over the immigration status that the employer has, either because he's providing her status, or as in the case of, I worked on the Postville case in Iowa, which was it was a kosher meatpacking plant that had lots and lots of undocumented workers, lots of sexual assault. I mean, I interviewed a 14-year-old sexual assault victim who was working in the factory. And they never went after the child labor exploitation charges, but they never prosecuted the sexual assault charges. Not surprisingly, unfortunately. But the power and control that they had, I mean, it was slave-like conditions. Women would have to fill in for each other. If a child got sick and the woman had to go home and take care of her kid, people went into the plant in the morning not knowing when or what time at night, whether it was going to be 8 or midnight, that they were going to be able to get out. And it depended on when the next shift came, how much. And it was slave-like conditions. It was really, really horrific. But the U visa helped many, many, many of those victims and their children, or their parents for the child victims. But that same power dynamic was going on there in the employment context. And we see it in farm worker condition. There's been a recent report by the Southern Poverty Law Center that talks about how this plays out for farm worker women as well throughout the country. And so citizen and lawful permanent resident spouses could decide when to file papers, whether to file papers. They could file it and withdraw it. There was all of this power and control going on. And so what we saw were a whole variety. Over the years, we've seen lots and lots of different kinds of immigration-related abuse. And immigration-related abuse is something that we've been one of the fun things about being a public interest lawyer is you don't always only do lawyering. So, for example, I had the privilege of being able to be on a team of researchers that I was, the lawyer policy person, I guess you could say, with these researchers who were able to document. I actually collected the data when I was at IUTA, and then I couldn't find it. I had to travel around the country looking for researchers who would actually analyze the data because there was so much of it. But we were able to prove that immigration-related abuse is a form of power and control, is a form of power and control dynamics that the Department of Homeland Security actually looks at and uses in adjudicating these cases now. And that kind of power and control, the immigration-related abuse, locks victims in relationships, and it essentially cuts off access to anything. Years ago, we were doing a training, I think we were in Santa Fe, New Mexico, and we brought together advocates that were working regularly with immigrant survivors, and we also brought survivors who were doing some organizing in their area among other women. And we separated them at one point, and we said to the victims group, what is the most important thing to you? And we asked the same question of the advocates and attorneys, what is the most important thing for immigrant women? And then we brought them back together, because the answers were very different. We brought them back together and we asked the victims, what's the most important thing to you, immigrant victims? And they said, immigration. And literally, the advocates in the room at the time jumped and said, but it's safety. And the women looked at them and said, but you can't have, if I'm afraid of being deported, how can I get safety? It was like the immigration fears blocked access for them to anything else that in the mainstream world we would consider victim safety. You couldn't get to those other victim safety issues if you didn't address the fear of deportation first. And so that's what we've learned, and that fear of deportation blocks them from seeking help, getting protection orders, calling the police. And that in 65% of the cases, National Institute of Justice funded research we did, we found that in 65% of the cases of immigrant survivors, victims report some form of immigration abuse as part of the pattern of power and control. And that what we've seen is that as a result, immigrant survivors stay longer suffer more significant and severe incidents of, quantity of abuse and harm, and that they also, isolation plays a huge factor. And that, I got that twice. And so they stay longer, they have fewer resources, and they sustain more severe consequences of physical and emotional abuse because of the role immigration-related abuse plays in locking them in and keeping them from either knowing about or getting services. And so what we see is that what does this mean in terms of the likelihood of abuse that an immigrant victim is going to suffer? And what we found is that lifetime incidence is about 50%, slightly higher than some of the higher numbers in the U.S. are reported similarly, but those married to U.S. citizens and lawful permanent residents, as I said, about 50%. But once we had a very interesting, the way we got to this next piece of data, I think I should tell the story because I think you'll find it fascinating. It's a great example of creative lawyering, and it's, it was a fun project to do, and it was really great. Anyway, after we passed the International Marriage Broker Regulation Act in 2005, a series of mail-order bride companies, international matchmaking countries, sued to enjoin its implementation. And I'll be talking about this case a little bit later, but what happened was they were enjoining the issuance of the regulations and the implementation, and in the federal district court case, the international matchmaking companies were arguing that in 1994, when we brought the data to Congress, we had conflated domestic citizens and lawful permanent residents. That we put the data together to hide the fact that the perpetrators were really all lawful permanent residents. So Arnold and Porter was working on a brief in the district court, federal district court in Georgia. The judge was inclined to go along with, was leaning towards going along with the arguments of the international matchmaking agencies. And they said, by the way, do you have access to that data, and could you tell us how the numbers change if you just look at citizens? I made a phone call to the person with the data. 15 minutes later, I called them back. I said, yes, it's 3 times the national average. That when U.S. citizens marry non-citizen women, the likelihood of abuse jumps to almost 60%, which is almost 3 times the national average. And so what we were able to do is I pulled together a bunch of researchers, and we published the data on Legal Momentum's website the day that the federal district court brief was due, and they cited it. And the judge cited it in his opinion ultimately. So it was one way we were able to actually dig into the real data, analyze it in a different way, publish an article, and cite it in the brief at the same time, which is some of the kind of crazy, I guess you could say, creative lawyering we do in these days, but it really made a difference. And it ended up that a second case got dismissed partially based on the same information later on. So, and what we found is that the data that Congress was looking at in '94 is that 72.3% of victims, of perpetrators who could file papers for the victim never does, and those that do wait almost an average of 4 years. And what's really interesting is we've also seen over the years that this immigration-related power and control is actually a lethality factor. And what that means is it doesn't just exist in a vacuum. It's not like if you have an emotionally abusive case that you'll have immigration-related abuse with it. Normally, immigration-related abuse is 10 times higher in relationships where there's physical or sexual abuse, and it appears to either corroborate the abuse like the old cut telephone cord did, or it's predicting escalation. And so it's really important, and we've been able to convince through training DHS to take this seriously as well, those that are in Vermont adjudicating the cases. The other thing that we found is that for immigrant survivors, when you look at the help seekers, the women that we knew were seeking help for domestic violence compared to the general population, there's a huge difference in the reduction of co-occurrence of child abuse and domestic violence in those cases. so that protecting immigrant moms really does help protect kids. And then, as I tie up, I'm not just going to talk about facts and figures and research, but I think it's important to understand as underpinnings of the work that this drives, essentially, politically, in terms of the laws we've been able to make change to. What's really exciting, and this is actually, it was just accepted for publication 2 weeks ago, which is very exciting. We did a piece of research looking at when immigrant victims were willing to get protection orders and what their decision-making processes were. Because the thought was they don't get them, they're afraid of the courts, it's just a piece of paper, etc. And what we found was that part of the reason women weren't getting them is they didn't know they existed. And so although almost 61% of victims who went to a social service agency or a legal services agency seeking help with domestic violence didn't know what a protection order was when they walked in the door, 81% of them chose to get a protection order. Better yet, there is a substantial correlation, a very strong statistical correlation between the severity of the violence and their choice, undocumented immigrant victims' choice of getting protection orders. Which means that the advocates and attorneys and that were doing safety planning with those victims, that it really worked. That the victims who were suffering the most harm were actually able to be convinced by lawyers, even though they were undocumented, and advocates, that they should go and get a protection order. And 96% of them found it helpful. 98% of them said they'd recommend the process to another battered immigrant. And there was a dramatic, for this population, we saw in the survey, which was across the country, multiple ethnicities, about 160 cases. And what we saw was that a dramatic drop-off in physical abuse following the issuance of the protection order in the whole populations, in the whole group surveyed, but that there were two areas of ongoing violations. One, not surprising to those of us who did protection orders, violation of the no-contact provisions. Number two, ongoing immigration-related abuse. So it appears that although it'll reduce the violence, the power and control of immigration and the immigration threats continue. We also looked at what effect immigration status has on the willingness of immigrant victims, undocumented, well, all immigrant victims, to call police for help. And what we found was even people who were stable, U.S. citizen, naturalized people who are naturalized lawful permanent residents, where there was really no risk in calling the police, were calling the police for help at lower levels than American-born U.S. citizens, and that rate dropped precipitously based on immigration status. So as we began to, so that was kind of the things that we did to create a background for the Violence Against Women Act and for immigration protections and the various different legislative achievements that we're going to talk about in a minute, was that kind of research survey background. But equally important was a process that we began of story collection, where we worked with advocates and lawyers across the country who wrote, 2-paragraph, half a page, page-long, essentially, descriptions of their client's experience. And that those stories, we'd gather them by state. We did storybooks, and we have them available on our website. If you go to the web library that I'll talk about at the end, you can type in story, and you can get books of stories. The original VAWA, we did it again for Violence Against Women Act of 2000 regarding something called 245I, where people, we were trying to get an exemption from having to pay $1,000 to get your papers in the United States, and an exemption that would allow immigrant survivors to stay here and apply for lawful permanent residency. We also did it for the U visa to get regulations out of the Department of Homeland Security for trafficking victim and U visa lawful permanent residency regulations. We've done it again for VAWA 2004. So they're really, really potent, effective tools that help not only describe to the legislators what needs to be done and why, but it really provides ammunition for allies inside the Department of Homeland Security, writing regulations to make their argument and make their case internally to fight kind of the hard fight they have to do to get a good set of regulations out. And we'll be talking about those kind of collaborations a little bit more. So VAWA's goal was there was dual goals. When we walked in and we're doing the lobbying initially, who would respond to which goal? You sometimes broke down by party, didn't always. So from my perspective, it worked for me just as well if somebody really cared about getting the bad guys and locking up perpetrators, or if they cared about protecting victims, because you could get them politically to the same place in terms of the legislation. What was really exciting about VAWA 94 and the VAWAs that have come afterwards is it was the first piece of federal legislation that was fully inclusive of underserved populations. Women of color, immigrants, the disabled, people based on their immigration status, limited English proficiency, rural communities, and which we're all really, really proud of and continue to be really proud of, and is part of the battle that we're going through right now, which I'll get to in a little bit. And so what did we achieve? As of September 30th, 2011, 68,000 self-petitions had been approved. We don't have numbers on the number of children included in those self-petitions because DHS didn't keep the numbers. They didn't have a data system for it. 35,000 U visas, 35,000 a little bit, U visas have been approved. We do know that those U visas include over 19,000 children. And 2,600, a little more, T visas, trafficking victim visas have been approved, with about 2,100 family members also getting benefits. So we've come a long way. That's like 100,000 people whose lives are different today because of VAWA and the trafficking bill, which is really exciting. Historically, VAWA had bipartisan support. I was looking at the screen and I thought it said prosecute anyway. And that for the reasons I said, people had different reasons for supporting it. Police that are involved in doing U visa certifications and helping VAWA victims are really some of our best allies right now. And I'll be talking about that a little bit more. And that this collaboration between advocates, attorneys, grassroots government, and finding a way to communicate between victims' rights and immigrant rights groups was really key. There were many, many, many times as we've done the work both around legislation and regulations where either the immigrant rights groups or the victim rights groups are like, we'll just do it this way because it's better for women, or we'll just do it this way because it's better for immigrants. And what happened is oftentimes neither is right. Because if you go too far in one direction or the other, you harm the other group. And so the struggle in this work has been to find a balance so that you're moving something forward for immigrant survivors without harming immigrants generally or women generally. And trying to keep both sides from running off in opposite directions is a real challenge. But it's also something we're very proud of in terms of what we've been able to achieve. So this gives you a picture of how bipartisan up until this year VAWA has always been. We've worked with, all kinds of Republicans in the House and Senate historically. Hatch, Abraham, Brownback have been massive supporters of this work, with Sensenbrenner playing a key role in 2005. And that one of the reasons, and so as I move into talking about kind of getting towards where we are today, it's important to understand why VAWA works for immigrant victims and why it works for law enforcement, because I think it gives you a good picture of kind of both sides of both parts of the goals of VAWA being achieved. So for immigrant survivors, it means that they're no longer fearful of threats of deportation, that they can actually it's a path to legal permanent residency and economic independence, They're more willing to call the police. They have better outcomes in their custody cases because the perpetrator can't just raise immigration status and everybody runs for cover, which is still happening in family courts. So immigration law has moved forward, but the family law challenges still remain and loom quite big. I got a technical assistance call, 3 weeks ago, from a judge that was trying to figure out whether he should turn in the victim in a protection order case to DHS for removal. So it's still happening. Fortunately, there's a lot of good resources, and if we can get on the phone with somebody, we can often talk them out of doing it. But that's why we need all of you, because we need more people out there who can do that work. For law enforcement, it really, law enforcement officers, I do a lot of training with law enforcement officers. One of the best in the country is actually up in Salem, Massachusetts, not too far from here. He's one of the most busy, if not the most renowned, FLETC, Federal Law Enforcement Training Academy trainers in the country on this issue. And, for them, it's serve and protect. And part of what we found is we're trying to figure out how can we help build, what do we need to understand about law enforcement and how they work so that we can get law enforcement and advocates and lawyers working closer together that result in positive outcomes. For example, U visa certifications and T visa endorsement. And it's really about community policing, and one of the things that we're finding, though, too, is that what really resonates with police when we train them is what's the most dangerous cases for police? Anybody know? Which former perpetrator is more likely to kill a police officer than anybody else? No. Domestic violence perpetrators. The likelihood of killing a police is exceptionally high, and many of them don't happen on the scene. If you look at, we're actually going to be doing some research soon on this issue, hopefully. If you look at police that are killed at Dunkin' Donuts or wherever they are, oftentimes those perpetrators have a domestic violence history and they're retaliating once they get out of jail or something like that. So that's one, it's a way to get police to pay attention and to care about doing this intervention, even if she's an immigrant, because it means that the perpetrator can be held accountable and they and their buddies are safer, as are our communities. So these are the pieces of legislation that we have been able to pass since the early 90s that benefit immigrant survivors. Battered spouse waiver in 1990, the Violence Against Women Act in 94, 2000 and 2005. We got welfare benefits for immigrant survivors in 96, legal services access actually in 97 and 2005. Funding for the unit that processes the VAWA cases in 2001, the International Marriage Broker Regulation Act in 2005, and healthcare reform. There was a big part of healthcare reform that helps immigrant survivors, which has to do with lawfully present immigrants being able to get access to prenatal care, maternal and child health care, which is a huge issue for immigrant survivors, domestic violence, sexual assault, human trafficking, sexual assault and human trafficking in particular. And then in addition, and that it's important to point out that post-1994, almost every single one of those pieces of legislation, particularly those that had to do with the Department of Homeland Security, there were federal agency staff working hand in hand with us in the crafting and giving us feedback to make sure that what we were writing was actually going to be able to work internally. And often the list of, we call it the kitchen sink list at the office. It's like the list of everything we'd like to change if we could. And a lot of that list sometimes came from the Department of Homeland Security, their own frustrations of things where they got stuck and they wanted to see fixes. And so we would sometimes try to work from both sides. They would work from the inside and we would work from the outside to try to push for the same things to happen. And that we also had an opportunity, again, giving you a broad picture of how your law degree can be used in many different ways. We worked with the Department of Justice, the Office of Violence Against Women, and we got the opportunity to read all of the grant reports for all of the people that were funded for a period of 3 years under the Legal Assistance for Victims grants. And we were trying to figure out what was the difference between the groups that were funded that were able to get U-Visa certifications and the groups that weren't. And what we were able to see in reading all these grant reports and analyzing them and running them through data and all this stuff is that what really mattered was real one-on-one relationships, where the group that was seeking certification, where there was an advocacy group or a group of attorneys that had been working with law enforcement on something else, on violence against women generally, on firearms, on something related often to violence against women, but where there was a history of working relationships together as part of a task force or something like that, those relationships fostered U-Visa certification. I mean, it makes sense, actually, when you think about it. And that when often attorneys, I hate to say it, but I might as well teach the bad and the good, right? When attorneys walked in and said, we got to go teach the police, teach them what to do, sorry, that didn't work because the police didn't want to be taught in that respect. So it was really about, what we found is that creating partnerships and sustaining partnerships and creating and sustaining real relationships where people have each other's work direct lines, sometimes cell phone numbers, really is what makes a difference. And it makes sense in a way, because when the law enforcement officer shows up at the scene of a rape or a domestic violence case, they can call the victim advocate or the lawyer and say, I'm bringing a client to your office the next day. That's what Marielle Varenga-Watkins used to do in my office. We didn't have cell phones back in those days, but I'd show up at work and she had a bunch of people with her. She became a police captain over the years, but at the time she was a street officer in my cases. She would literally bring me a bunch of clients. And by working with those clients, then they start bringing their girlfriends. And that's kind of how my caseload evolved at AUDA all those years ago. So it's about developing those relationships that are trusting, respectful, and I guess you could say co-equal, so that it's not like the lawyer isn't better than the police officer and the police officer isn't better than the lawyer or the advocate. It's all part of a team that's helping the same victim. So this is my best, I'm not good on flowcharts, but this is kind of my best attempt to kind of explain, I guess you could say, my career or what we have done over the years. And you can start actually anywhere in the circle, but I think the key to being successful in working from a public policy perspective with immigrant survivors is understanding that, you pass one piece of legislation and some people then move on to the next piece of legislation. Well, we never did it that way. We would pass one piece of legislation and then we would say, okay, now we have to implement that piece of legislation. And then we would start working on the implementation and try to help in, providing memos and legal memoranda and analysis on what the regulations should look like. Now, those of you that might teach the Administrative Procedures Act might wonder how we did that. Well, what we did is we didn't have conversations necessarily with DHS. We actually just wrote memorandum, what we thought it should look like, and we just send them. And we just send them unsolicited into the world of DHS. And basically what we found is they landed, that they were able to, it gave them the information and background. Initially that's how it happened. Now we actually publish reports and do things like that they can turn to. But the point is that you can't stop with you can't stop with writing a piece of legislation. You have to actually do what you can, other than just notice and comment if you can, to try to educate and provide information so that the people on the inside that are doing the writing actually have the information they need to do it right. And there are ways to do that without violating APA, largely by just publishing things. So for example, in a couple of weeks in my class at AU, teaching a seminar and practicum, we're actually going to take the provisions of the Violence Against Women Act that are identical in the two bills, and the students are going to have a reg writing assignment for homework. And then we're going to turn that in as proposals of what the regs should look like, ideally. So there are ways to affect that. And then there's training. There's traveling around the country teaching people how to use the law. And I find that that is an essential part. I can't, as much as my husband would like me to, I can't just sit in my office and do this work. Because traveling around the country, meeting with people, talking to them, you know, it's the only way to really keep your finger on the pulse and understand what's really happening. And continuously people will raise their hand. And once I had a case where somebody raised their hand and said, I think this is a silly question, but all the judges in my jurisdiction are denying protection orders to immigrant survivors because they don't want to give them immigration status. Or all the transitional housing programs are turning undocumented immigrant victims away. Or legal services program I went to the other day, you know, this happened a week ago, turned my client away because they were undocumented. Well, the law has changed. All three of those things are wrong as a matter of law. And if what happens though is you got to get the word out to people and then give them tools so that they can make those changes in their community. So through the training, and then we also do technical assistance, we identify the problem. And once we have identified the problem, the next thing happens is people say, okay, you go right back to Congress and change it. But a lot of times the problems can be solved without going back to Congress. And they can be solved because by a whole different kinds of things. Sometimes you can write a practice manual or a tool that's funded by the government that teaches people how to do it a different way. And some of the problems get solved that way. Sometimes you can go in and train the adjudicators at DHS. Or you can work with an agency locally to issue policy or protocol. You can try to get regulations, you can try to get an executive order, and if you fail on all that, then you're back to legislation again. And that's kind of how it all fits together. I see it as a complete circle, really. So what I wanted to do now is shift over to, as I move towards VAWA 2012, 13, whatever it's going to be, VAWA 4, I want to talk first of all, about all the things that you can get by agency policy or regulation, because there's a huge amount of this work that occurred that way. So we got Violence Against Women Act regulations in 1996 that were the self-petitioning regulations that were quite sensitive to the dynamics of domestic violence experienced by immigrant survivors. Those were the memos we were sending into the stratosphere. We weren't quite sure where they were landing, but they worked. We've got great regulations on policies, programs necessary to protect life and safety out of the Department of Justice in 1996. The VAWA unit was created in 1997, and it was created because we documented all the district offices nationally and what was happening and the stories of the cases that were stuck. And then we worked with the Department of Homeland Security that had us, back to my fax machine, had us actually test. They set up a system in the regional service centers that was trying to help adjudicate the cases that were stuck at the district offices, so that they had us send essentially a memo about how they should be doing this at the regional service centers to all of the regional service centers in the U.S., and one responded, Vermont. And that's how it ended up there. And it responded because there was one guy who actually ended up running the unit who really understood domestic violence. He was an EMT. He did, on the side when he wasn't working for DHS, he ran the fire truck in his community and had seen a lot of this. And he took an interest, and he was the guy on the other end of the fax machine. The faxes were signed by the district director, but they were coming from him. And so it's a great example of how one person in the right place at the right time can make a difference. And I didn't know that was happening until about 3 years later, that we had a conference in Austin, Texas. And after the meeting, we went out to a bar someplace, and I was sitting next to him, and I looked at him and I said, "Were you the guy on the other side of the fax machine?" And he said, "Yes, I was wondering how long it was going to take you to figure that out." Because he couldn't tell me. He's still working for INS at the time. But the point is that it's really important in this work to have those partnerships. So we got Kennedy Amendment implementation from Legal Services in 97, confidentiality implementation from the Department of Homeland, or INS, in 98, access to transitional housing for up to 2 years, 2001. It was actually January 20th, 2001. Anybody know what day that is?
Bush's inauguration.
The day before, yeah. Yeah, I think the 21st was the inauguration, the 20th. So the day before we got HHS-funded healthcare, those two memos, the last two on the list, came out the day before the inauguration, Bush's inauguration. But what was really interesting is the access to shelter and transitional housing has never changed. The Bush administration never moved to change that policy, and it is the policy today. In the next 8 years, we got funding for the development. Well, first of all, from 1997 to 2012, the VAWA unit was developed, was shaped. There was training. I actually looked earlier today. I was wondering when I first went to do. First training was late 1998, and we've been involved in training the VAWA unit ever since. And that it is successful in, ferreting out fraud, and I'll talk more about some recent findings on that now in a few minutes, and granting at the same time granting immigration protections to immigrant survivors. So between 2001 and 2008, we got DHS confidentiality implementation in 2005. We have one of the memos. There were two of them. One of them is still mysteriously being held up by FOIA. I don't know if we'll ever see it, the one for the immigration lawyers. But we finally got U visa regulations in 2007, and I'll just tell you a little bit about how that happened, because I think it's important to understand kind of how us public interest lawyers do our jobs, I guess you could say. There was a group of the regs were actually about ready to come out in 2005. There was a group of public interest lawyers who decided they were going to sue the Department of Homeland Security for the regs, and guess what happened? It delayed them, because the lawyers got involved at the Department of Homeland Security, and the whole process ground to a halt. And so in trying to get them released, we collected stories from all over the country, which helped in terms of the internal writing of the regulations. But in the end, we went to David Price, who at the time was the chair, I think he still might be. No, he was the chair of the Department of Homeland Security Appropriations Committee, and talked to him about the problem. And so what he did is, in the budget bill, DHS wanted to renovate a new headquarters, and the money was in the budget bill. And he approved the money in the budget bill, and he said, you only get the money after the U visa regulations come out. So guess what happened? The U visa regulations came out. So there's all kinds of really creative ways you can make these things happen. Then we got the T and U adjustment rules, which were the lawful permanent residency rules in 2008, and fee waivers in 2008. Those last two things, again, all three of those 2007, 2008 accomplishments, those three in the middle, were really, 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 there were people on the inside at DHS who were working lawyers who went to work for the government, who were working super hard and were key to making that all happen. We couldn't have done it without them. No way. And so it's important to understand, it's not just advocates on the outside pushing, it's hopefully getting people who take those government jobs who really care and it's lining up the stars, I guess you could say, both from inside the government and outside, to kind of push those things and make it happen. It wasn't random when David Price did what he did. We had an idea that it was already to a position, it was sitting on somebody's desk who was refusing to move it. So there was an ability to move it, which we knew before we went to him. So now what I want to do, oops, what happened? Went to the end. Sorry, guys. Okay. Am I going? Which way am I going? Sorry, I can't get back. Okay. So What's happened more recently is that, how many of you have heard, I'm sure everybody, about the deferred action for child arrivals? Okay. And how many of you have heard news reports that, like, all of a sudden, Obama's doing this for Latinos votes, right? But the issue is that this administration has been working on a whole series of policies that have been designed to shift how DHS does its work, where it puts its priorities, where it doesn't, and there's been a dramatic improvement, a whole series of policies that have been really, really, really important to immigrant survivors. So as a result of I think it was initially Postville, and then, what's the raid you worked on, Hema? New Bedford. Prior to those raids, there were no humanitarian release policies. Because of the work that a lot of advocates did in 2007 and 8, ultimately the Bush administration issued humanitarian release policies, but only for raids and only for employment raids over a certain number. Like, originally it was only for big raids, and then they reduced it to if they're going after 25 or more people. But individual cases still had no protection. What's happened beginning in 2009, that protection for humanitarian release, and what that means is if let's go back for a second to Postville. I'll give you an example of what happened in Postville. Current law, because of humanitarian release and because of some additional policies I'm going to talk about in a minute, current law says that when DHS stops you, they're going to ask you whether you have children. Now, if you're an undocumented woman with 2 undocumented children and you get picked up at work, your general inclination is going to be to do what? What are you going to say when they ask you if you have children? No, you don't. Well, it turns out what happened in Postville is that the women who said they didn't, even though they did, ended up deported. And the women who admitted to having children, even if they were undocumented, were the ones that got humanitarian release, ultimately found themselves away to lawyers and got U visas. And so one of the things that we do training all over the country, and we just actually took me 6 years, but I got the Office of Violence Against Women finally to approve a Know Your Rights brochure for advocates to use with immigrant victims. And what it focuses on, things like that. First thing to tell your client, if she's a mother, she's stopped by DHS, tell them you have children. Because if you have children, they're not supposed to detain you. And their policies are that they're supposed to ask you at the site, they're supposed to ask you at the detention center, et cetera, et cetera. We all know, but generally speaking, what I can say is where it hasn't happened and we've gotten technical assistance calls, we've been able to get DHS to turn itself around pretty quickly and release the victim. And that's newer now. So breastfeeding mothers, sole primary caretakers of children, that's humanitarian release. In 2010, we got post-secondary educational grants and loans for VAWA self-petitioners. I am hoping that by the end of 2012, we're in negotiations right now with the Department of Education to get, and we just did a survey that people were just amazing. We started using SurveyMonkey to do surveys nowadays. And the Department of Education gave me a week to do a survey, with the return date on the survey being the day after Labor Day. And I thought they were kidding. But they said, no, we have a deadline, we have to do this. We got 168 responses reporting on over 7,000 cases of U visa victims from across the country, that we were able to get the data back to the Department of Education to support the argument that what we basically found is 98.2% of U visa victims know they qualify for lawful permanent residency before they apply. The other 0.8% are people that are planning to go home. And so what that means in terms of Department of Education is that those victims can get post-secondary educational grants and loans, and so can their kids. So we're pushing for that right now, and we're hoping to maybe have that by the end of the year. I talked about healthcare reform. But these are the series of DHS memos that the department has been issuing over the last 2 years. kind of ending, or a year and a half, 18 months, ending with, not even ending because there's more that's come out recently, but before they issued the deferred action for immigrant children. We worked for about 6 years with the Department of Homeland Security, encouraging them, and they finally did issue a computer check system. So if a victim is picked up, let's say both of them are picked up in a dual arrest and the victim gets detained, they take her fingerprints and they send it through the Secure Communities program to DHS. They're now somebody that's supposed to be receiving those fingerprints who should be checking, has a computer system they can check and treat a battered immigrant with a pending VAWA case or a U visa case as if they were a U.S. citizen and tell the local police we have no interest in them. That's what's supposed to be happening. We actually have some meetings set up with DHS next week or the week after to kind of work out making sure they really are checking the right computer systems. But the system exists, and if you're working on a case and that becomes an issue, we have the actual broadcast facts that went to the field and DHS up on our website, so you can download it and take it into wherever you need to take it. Prosecutorial discretion in crime victims cases, they basically are discouraging not only crime victims, but witnesses, people who bring, EEOC sexual harassment cases that wouldn't be covered by any form of immigration relief. They're discouraging deportation of those people. They're low priority for deportation. And then essentially halting proceeding. What happened was there were a series of directives issued that were designed to halt removals and require all of the trial attorneys at the Department of Homeland Security review all of their cases. And what was supposed to happen, and I'm looking at Hema, I'm sure there's other immigration attorneys that are, what I've heard is it's not resulting in as many dismissals as it should have potentially. But what's supposed to happen is if somebody at DHS wants to continue with a deportation case against somebody who's a low priority for removal, they have to get supervisory approval. And so that is a deterrent to both bringing the cases and continuing them. I mean, how effective it's going to be able to tell, we'll see over time. But basically for immigrant survivors, what this means is you have VAWA confidentiality protection against removal as soon as you file your case, so that if you file a protection order and you serve the batterer with papers, and he then calls DHS to show up at the courthouse and pick you up, they'll already have a case in the system that should stop them from going. They should be stopped from going because it's illegal for DHS to do enforcement actions at courthouse since VAWA 2005, but they're still doing them. So it's like another mechanism to try to hold that off. Did I go down? It's not going down. What's going on? Hold on. Somebody. No, that wasn't the answer. Okay, let me just do it this way. Sorry. It's not my own computer, so I'm like, where are we? Okay. Now will it go down? Yes. Okay. Okay, great. So let me do this then. These are positive and negative factors that they look at for keeping people in the U.S. I'll skip to that, and then I'll just go. I can give you, these will be available on our website, so if you want to look for more details. What I want to do is just end. I'll spend like 5 minutes on VAWA 2004, or VAWA 4, VAWA 2012. The immigration provisions are the center of the controversy. There's also concerns about LGBT and Native American provisions. The LGBT and Native American provisions in the Senate bill are really great, necessary advancements that everybody wants to see in the final bill. The immigration provisions are that, but they're the place where everything's going backwards. So what's happening is that the immigration provisions are actually taking relief away from people that currently have it, and they'll make it retroactive to anybody who has a pending case on the date of implementation. And so it was designed to cut fraud, but government studies, both USCIS and Congressional Research Service, are not finding fraud in these cases. And that actually what's happening is that because the VAWA unit is so diligent, There are more requests for further evidence in VAWA cases than anything else because they're being careful and they're trying to get the evidence. The approval rates are relatively low based on, they're lower than family-based petitions. Some of that has to do with fraudulent petitions. Some of it has to do with notarios and other people who take advantage of victims, charge them a lot of money, and don't really do a good VAWA case. And that what's important to understand is every VAWA self-petition where they're claiming all this fraud are people who are married to U.S. citizens or lawful permanent residents and haven't filed, and where the perpetrator hasn't, or the spouse hasn't filed papers. And so it doesn't make a lot of sense that there's a high level of fraud in these cases. In U-Visa cases, the government research is finding no fraud, and there's about a 22% denial rate. That comes from people who can't show substantial injury or people who have serious criminal backgrounds where they don't get a waiver to get their visa. The people behind the whole fraud story, remember earlier I was talking about the international matchmaking case? There's a group called SAVE, Stop Abuse in Violent Environments, and their treasurer is a woman named Natasha Spivak, whose company, Encounters International, got a $434,000 civil judgment against them. I actually know that case because I was involved. The nurses who first encountered the victim called me. And essentially the facts were that she knew about the abuse. She told the victim she had to go back to her perpetrator or she'd have her deported. The victim stayed. She didn't give her information, and ultimately the victim was harmed. And that's who is on the Hill trying to fight VAWA right now. There are also individual cases. There was a case in which a victim testified in July that has been a center of a lot of the controversy around VAWA. The problem was her case, if her husband, there are probably cases where people sneak through who may actually be perpetrators, for example, as in her case. But that case happened in 1998, right when the VAWA unit was being formed, probably before they were ever trained. And so, and cases of individual trial attorneys who were doing VAWA cancellation cases who were trying who want to get rid of VAWA. There are a number of provisions, as I mentioned earlier, in both bills, really important ones for U-Visa kids, public charge fixes, and a number of other things. The Senate bill will increase the visas by 15,000, will add stalking in addition to the other fixes. The House bill, however, will authorize DHS to consider perpetrator-provided information, mandate an additional interview at the district office for victims, mandate considerations negatively, not positively, not unbiasedly, just only negatively. You can take a negative inference from the fact that prior petitions might have been filed, although they may contain really good information that would help the victim's case. And there's a variety of other problems with the House bill generally. The biggest one is it will get rid of lawful permanent residency for almost all U-Visa victims. So it's a really, really bad rollback. And that we're hoping, essentially what we've been able to do is gather stories from police. The police officers that we train with around the country have been collecting other stories and statements from police officers around the country to try to counter what's going on. Researchers have come together and given information and stories from the field, and we're hoping, after the election, maybe something can happen lame duck. And if not, it's a must-pass bill, and we'll be facing it in 2013. So I'll stop there. Almost 15 minutes for questions. And this is where you can get further information. Thank you very much, and I'll be happy to take questions. Questions? Nobody has any questions. Yes? Yes, it includes both. It includes, in the population samples, we were looking at immigrant women who, without regard to what the status of their spouses were, of which a section of that were people married to U.S. citizens, lawful permanent residents. The rest could have been married to people who were undocumented. They could have been not married to their partners. All of that. So it was, and the protection order research wasn't limited to people who were married. It was only people who could get protection orders in their states. It was, it didn't include same-sex couples, the protection order research, but intimate partner violence against male-female. Questions? Yeah.
Are there any treaties that protect Americans in their world?
Very interesting question, actually. Not that, no, there's not. There are custody treaties, there are child support kind of treaties, but there's not really anything internationally that is a treaty per se. There's an organization in Oregon that is actually, and we're going to be talking about this on the panel we're doing on Wednesday, because I think Belinda Applegarth is really involved with, there's an American Overseas Women's Organization that does technical assistance to American women who are abused abroad. And are trying to get back with their kids. It's a whole other part of this work that is very complex. A lot of it has to do with Hague Convention cases and family court. Yeah. So, but other countries, I mean, there are countries that have, I mean, many of the Western European countries, for example, have protection order statutes and things like that, but there's nothing international that I know of. If somebody knows more than I do, I don't know. But I mean, it could be out, but I don't think there's anything out there right now. Yeah?
Can you talk more about the provisions, the protections that the House is trying to take away from
What I understand, I'm not the expert on these, but I can tell you a little bit. I know, well, yeah. Okay, so the LGBT provisions are designed, what's going on with LGBT survivors is a lot like what happened with immigrant survivors in the past, which was when we first passed VAWA, everybody was supposed to be included, but in an actual practical sense, victims weren't getting services. Immigrant victims or LEP victims weren't getting services. So there's been a lot of work done, and because of that, in VAWA 2000, we included alienage status as an underserved population to help drive the services to that population, which it in fact did. What's happening in the Senate bill is they want to add the LGBT communities to that underserved population to help drive services more to LGBT survivors. The House doesn't want to, the House isn't willing to accede to those provisions. So that's what I know about the LGBT. Did I miss anything, Hema? Yeah, I think that's what's. And then the Native women, what happens is there was a provision, the way protection order, because Native populations, Native tribes are countries, they're their own, they have their own legal systems. What was happening is in the original, I don't remember exactly how it got done this way, but in original VAWA and its successors, protection, or essentially as it is right now, if you are a Native woman and you are abused by a non-Native male perpetrator or female, either way, if you're a Native, gender isn't the issue. On the reservation doesn't have an ability to do, got it wrong? It's the other way around?
No, that's right.
Okay. The reservation doesn't have jurisdiction to issue the protection order against the U.S. citizen. And so what the Senate bill does is give full faith and credit. Basically, it allows a protection order, the tribe to issue a protection order, just like a state can, against anyone who perpetrates domestic violence without regard to that person, whether that person is Native or non-Native. And what they're objecting to, what the House is objecting to, is that, you know, U.S. citizens will then be subject to protection orders by Native American tribes. And so that's the issue. And so the Senate bill corrects that and the House bill deletes that provision. Yeah?
A little bit about the Department of Education
Grants.
grants.
Mm-hmm.
Can you talk a little bit more about how they're going to give grants to local
I can tell you what we're advocating. Yeah, I'll tell you what we're advocating. Well, I'll tell you first what they did in 1996 when we got welfare reform for battered immigrants. What it was supposed to do was give post-secondary educational loans to battered immigrant VAWA self-petitioners and their children. It wasn't until 2010 that we actually got that to happen. So now there's a letter from the Department of Homeland Security to the people that do grants, FAFSA and in all the universities around the country, saying, here's how you do a case if it's a battered immigrant, self-petitioner, or a child. And in the conversations with them, it became clear that the education statute says we give post-secondary educational grants and loans to anybody who's here for other than a temporary purpose, who intends and basically has a path to lawful permanent residency or citizenship. So the question about U visas is it other than temporary, and is there a path? And the legal research that we just turned into DHS to Department of Education together with the social science research, the SurveyMonkey research, is what we found is that if you take, I think there's 84 different kinds of immigration status you can have. And if you take them all and you analyze them, what you'll see is there's ones where the applicant victim or the applicant is in total control of whether they apply for lawful permanent residency. They don't depend on anybody else. It's in their control. And then there's a whole other group where an employer has to file, a spouse has to file, et cetera. And so what we're arguing is that the U visas are one of those where the victim can control her own level of cooperation. And if she already qualifies because she can show humanitarian need, public interest, or family unity, which is what you need to do to get lawful permanent residency, then she would qualify. So we're arguing that U visa applicants should be, and their children should be able to get it. I don't know whether they're going to land on applicants, recipients. It should be one of those two, but I'm not sure where in that trajectory they're going to land. No. It's FAFSA. Right, it's post-secondary educational grant. So they'd have to qualify in every other way, but they're able to file those applications and be eligible. So it's more than DREAM Act, because it's people who will actually, they're on a way to a path and they can get federal benefits, even though they're undocumented. Yeah.
I really thank Leslye for giving a wonderful, wonderful talk. I know people have tons of other questions, but she's here for the next 2.5 days and available to meet with you. Catherine Schulte from the Domestic Violence Clinic has put together a wonderful roundtable that will be in this room on Wednesday. Do you want to say a word about that?
Sure. So the event on Wednesday is we have the title of the presentation is Emerging Issues in Family Law for Immigrant Survivors. So we have a really wonderful group of practitioners and trainers who deal with these issues on a daily basis, who will be coming in to discuss kind of the more family law side of the challenges facing immigrant survivors.
And of course, Leslye will be part of that panel as well. And we have something for you.
Thank
as
you.
Well.
My
but
goodness.
if you want to meet with Leslye, Janice Galligan is the person who has the sign-up sheet. She'll be available to students for the next 2.5 days.
Right.
And thank you so much,
Thank
Leslye.
you.